So at the time that you were in that house, Jerome Faulkner had been shot with his crossbow. And you're telling the jury, as you said yesterday, and as you've told Detective McPhee, that your father pushed the stirrup of that crossbow against the floor and put his foot in it and used both hands to pull that string back. Is that what you saw?
I don't remember him reloading.
Good afternoon. Welcome to the Law News Network. I'm Misty Marris. We're in the midst of rewatching some testimony from the Eric Campbell trial. Eric Campbell, found guilty of first-degree murder, soon will be moving into the penalty phase of the case. Looks like that's not going to happen until September. We were just watching Eric Campbell's testimony, which was put on the stand to show that he was actually coerced into committing these crimes because he was so fearful of his father. Obviously, the jury did not buy that. Only 2.5 hours did it take to deliberate and find him guilty, now facing the death penalty. I'm here with my friend and colleague, Aaron Keller. Aaron, thanks so much. Can we talk a little bit about Eric Campbell? I know that this case was really riveting to us. Interesting defense move. This wasn't an insanity defense. This was just, my dad made me do it.
Well, it was an interesting move, but I think the jury made the right decision because ultimately, okay, even if there was coercion, as I recall the testimony going in this case, the prosecution was able to show that he had opportunity after opportunity to leave or alert someone. The scene that's coming back to my mind is this scene somewhere in a Walmart parking lot where apparently the son went into the store and then came back out and rejoined the father. Well, the son kept saying, well, my dad would have gone in, he would have gotten me, something would have happened to me. And okay, I don't know if I buy that, and the jury didn't either. Because here's the bottom line. If somebody were coercing me and then let me out of their sight, and I went into a place where there are alleged, where there are trusted people, I would have gone to the customer service counter or something and said, my father's planning a crime and I need to call the police. You need to get the police here. There's another way that this thing could have gone down other than the father and the son going off and killing this poor elderly couple in North Carolina. So I think the jury made the right decision in not buying the coercion story lock, stock, and barrel.
Yeah, I agree with you. And I'm not even sure that the coercion piece matters because he clearly said, Eric Campbell, he did not want to participate in the robbery, but he did. And that resulted in the death of these two individuals. So from an accomplice liability point of view, does it even matter whether or not he wanted to do it? And you made a great point. Ample time, ample opportunities to retreat. Obviously, that factored into the jury's decision. But even without that, the reality is he did participate.
I'm trying to remember back to the old bar exam rule, and that's that if you're part of a conspiracy, you've got to do more than just sort of back away from it, okay, once the events get set in motion, right? So he didn't even just back away from it and nonchalantly put his hands in his pockets and whistle as he was walking down the street. He certainly didn't take any effort to try to call the authorities, which is what he would have had to have done to, try to put a stop to it. Okay, that's what he would have had to have done to withdraw from any kind of conspiracy, if that's what this was. Coercion's a little bit different. But I just don't know if I see it here because, okay, maybe it was coercive, but did it legally hit that mark necessary for legal coercion? I don't see it. Usually legal coercion has to be somebody with a gun to your head saying you need to shoot these people or I will shoot you.
Exactly. That's the example.
Psychological coercion here, it probably was present, but the jury found that he at least was thinking clearly enough and at least had enough of an opportunity to escape to try to do something other than just keep the train moving down the tracks.
Right. It didn't negate his culpability. The jury obviously found him guilty, but here's the interesting piece. I'm interested in your take on it. So now what? Now we move to the penalty phase of the trial. Actually, the evidence that was brought forth by the defense with respect to Eric Campbell's mental issues, some of his psychiatric issues that he had in the past, his father's role in these crimes, that element of being fearful of his father, that may actually weigh a lot heavier here in the penalty phase when you're talking about mitigating factors.
Oh, certainly. I mean, this is all about saving this defendant's life for the defense team. So a couple of things. First of all, North Carolina is not the sort of state that frequently sends people to death row. It's very rarely applied. So from a cultural perspective, he's got a better chance than he would if this were Texas or Florida or a state that executes a lot of inmates. Okay, so it's rarely applied. In this case, if the father were alive to go to trial, then I would say, yeah, it's more likely than not that maybe the father would get the death penalty. But all of this evidence that this jury has been hearing about this individual claiming an element of coercion, claiming that there was all of this psychological abuse, physical abuse within the family. I mean, that testimony, my guess, is enough to save this defendant's life because he grew up in a mess.
Yeah, and there's no, that we definitely saw throughout the course of the trial. We saw some family members testify. We saw experts. He certainly, his dad was not a good guy. I think that was pretty clear from what we saw.
No, you know, and it's like the father committed suicide when he was in custody for this particular thing and left the son to face the rap. Well, by all accounts, the father was the ringleader. We don't have him to put on trial, but the bottom line is a lot of juries reserve the death penalty for what they perceive to be the worst of the worst of the worst. You know, people who are premeditated cop killers, people who just go off on the worst premeditated crime sprees possible. Those people tend to get the death penalty. Now, granted, this was a crime spree that resulted in these two murders and havoc over a number of different states, but was that defendant, was Eric Campbell the one who really set it in motion? Was he the ringleader? I don't think there's much evidence that he was.
Yeah.
I think there was evidence that he went along with it. Why? I don't know, but I'd be really surprised if we actually get to the death penalty here. It's bad. I'm not excusing it. You know, does he deserve to be locked up for a long, long time, maybe even life in prison? That sentence, I don't know if I would disagree with. But given the family dynamic, that penalty seems a little bit harsh to me, at least.
Yeah, and you make a great point because oftentimes when you do have accomplices or felony murder or something like that, very often you'll see the people that weren't in the forefront will escape the death penalty in these cases. And the ringleader, like you said, his dad, if he hadn't taken his own life, you might see him standing really facing a capital murder punishment. What kinds of aggravating factors, though? So if you're convicted of first-degree murder, you're not immediately subject to the death penalty. Generally, aggravating factors have to be present. So you know the prosecution is going to push really hard. What facts do you think they're going to focus on in this case?
Well, I think the fact that the son continued to go along with it, facts that would indicate that the son played more than just a passerby along for the ride role. I think the son had something to do with procuring the weapon, although I'm reaching way back into my memory to the beginning of this trial. And again, this is an issue the jury's going to have because we shut the case down for a month because the one juror was in a car accident. So I wish I could give you a more direct answer, Misty, but I'm trying to remember the evidence myself.
I'm with you, Aaron. I mean, we cover a lot of trials here too, so it's really, you're getting into the nitty-gritty here, but certainly the brutality of the crime, the fact that they set the house on fire, the beatings, all of that stuff is going to come out. The question is, will it be enough to tip the balance in favor of the death penalty? And I have to agree with you. I think in this case, some of those mitigating factors are really going to take the forefront. Mm-hmm. But what about the victim impact statements? What do you think what effect is that going to have? Because we already saw the victim's family come forward and say, oh my, this has been such a long haul. Thank goodness justice was served. We've been waiting for justice, losing our family members, and you know they're going to have some emotional statements coming forward. This was a random crime for the Faulkners.
Oh, it was absolutely disgusting, and I feel horribly sorry for the families, but it goes back to the old question we always have to answer here, and that's a question as to whether or not sentimentality or whether or not rules should govern the day in a courtroom. And the bottom line is that it's about what you said. It's about aggravating and mitigating factors. What did this defendant specifically do to deserve this specific type of punishment, whether that's the death penalty, whether it's life in prison, whatever it may be. So I tend, and maybe this is just me becoming callous after having watched so many of these things go by, but I'm more interested in whether or not the law is being accurately applied. We know that family members are sad. We know that this was a dear couple who was respected very highly by their friends, their family, their community, and we all feel horribly sorry when we have to cover cases like this. But the question as a matter of law, the question in court, if we're a society that's to be ruled by law, is whether or not that defendant did something so egregious to deserve the absolute worst punishment in the land. And if he did, well, then the answer is yes, death penalty. If the answer is no, it's the next serious punishment in the land, which is life in prison. So, you know, some states, judges have to, or juries have to consider victim impact statements, victim testimony as part of this mix. In other states, they don't. I haven't dug that far into the North Carolina statutes to see whether they have to consider it. With this sort of crime, I think it's really going to be more the aggravating and mitigating factors in the statute, I should say, than it is going to be kind of a sentimental thing. You know, what did that defendant do? Did he get the weapon? Did he pull the trigger? Did he drive the getaway car? Like, what did he actually do? That's what the jury needs to focus on. In lesser crimes, we see victim impact statements playing more of a role. The Michelle Carter case that we covered out of Massachusetts. We were having the debate around the table here with the Dan Abrams sitting in your chair. And one of the things I said when the judge said, okay, I've listened to the victim impact statements, I'm going to take a pause and be back with the sentence in a moment. And we were all sitting back here saying, wow, is he actually going to change his mind after listening to this? And then, you know, the light bulb went off in my head. That's right. In Massachusetts, in a juvenile proceeding of that nature, the statute says the judge shall consider victim impact statements. So the judge had to consider it in that circumstance. So the judge took a pause, he considered it, then he went and delivered a sentence. I think with a first-degree murder charge, we're in the land of aggravators and mitigators. We're not in the land of really considering victim impact statements.
No, and you make such a great point in that front, because really those aggravating and mitigating factors are supposed to be what dictates the day for, as you said, the highest punishment you could possibly get. But what about juries? It's a little different when you have a judge making the determination on a sentence. Juries can be swayed by emotional factors.
They can, but the more I watch these cases go by here at LawNewz, the more faith I have in the jury system overall. I think that juries take their jobs seriously. They're taking time out of their lives. They don't want to screw things up. And look, you know, public sentiment being what it is, I think public sentiment is oftentimes more swayed by sympathy than juries, because juries, by the nature of the chairs in which they sit, have to sit and listen to both sides of the case, and they have to sit and listen to the judge explain the law. Okay, a lot of people who watch trials, perhaps not as closely as our viewers, because our viewers watch that very closely. A lot of people just look and say, oh, he did what, or he was involved in what? Well, he should get, and then they just throw a punishment out. Well, the question is, does the law allow that type of punishment for that particular act, and should it? Okay, the jury sits and listens to the law, and I think most juries, 90+% of the time, really take that seriously. They want to get the law right, because if this was just a popularity contest, then I would hate to be a part of this criminal justice system.
Oh, definitely. And juries do. They take their jobs very seriously. Certainly in this case, the result is a very serious result. This is somebody facing capital punishment, and they've been convicted of a very serious crime. So in any event, we'll certainly be covering every aspect of that sentencing hearing. But right now, we want to switch gears a little bit. Obviously, in the Eric Carter case, big piece of that puzzle is what was Eric Campbell's state of mind? What were his psychological issues leading up to the commission of this crime? Well, we have another case where state of mind is certainly a key factor. This is the Adrian Loya case. Aaron, take us through some of the facts of this case, because we were talking about this before. This is really, there's a lot of twists and turns here.
Oh, this is one of the most bizarre cases that I've come across in quite a number of years. You've got these Coast Guard members, okay? The defendant is accused of driving from Virginia up to the southern hook of Cape Cod, busting into this house, okay, that's occupied by 2 other Coast Guard members. They were married, Lisa and Anna Trubnikova, okay? He shoots and kills one of them, shoots and very seriously injures the other one. The testimony that's coming out today from the courtroom that we wish we could show to you, but we can't, is indicating that both of them didn't register a pulse, and then they realized that one of them was actually alive, that one of them had survived. Okay, so then he goes and shoots a cop who's responding to the scene, and you've got all of these fake bombs and flashbang canisters and smoke canisters and all this other stuff scattered all over the neighborhood. It's 5 degrees out. It's February 2015, okay? Then, you know, there's this car on fire in the only entrance into the neighborhood, okay? So the allegation is not only does he plan this thing out in detail, he gets all these fake bombs put together, he torches the car somehow to try to prevent the police from responding. They're afraid there's real bombs in the house. And they're saying, it took us a long time to render aid to the victims here because we just didn't know what we were facing. Now, the defendant is claiming mental disease or defect. It's coming out in testimony that there's a claim that the victim who died had somehow sexually abused or assaulted the defendant when they were in the Coast Guard together and they were all stationed in Alaska. And that somehow set him off enough that he thought that she deserved this absolutely bizarre, horrible death. And he travels all the way to Massachusetts to do it. I mean, just the circumstances are among the most bizarre circumstances that I can recall hearing in quite some time.
Yeah, this is going to be a crazy case, and we're going to be live streaming tomorrow, so we'll be back in the courtroom. But Aaron, some of that information that you gave me, some of those facts, they don't really fit in with an insanity defense. Insanity is that you're unable to appreciate the criminality of your conduct in Massachusetts. So when you have something that looks like it's a bit premeditated, fake bombs.
I think it's more than a bit premeditated.
Yeah,
See,
a car lit on fire so the service can't be rendered to the victims. A manifesto, we didn't even get into that, but
there's
a
this
writing
manifesto
about
out there.
why. And even right there, a motive handed on a platter to the prosecution. Well, I was sexually abused, something about a relationship in the past that led Loya to commit this crime. All of that does not fit in with, I don't understand the criminality of my conduct. It seems that you do understand that the conduct is criminal, and in fact, that's what you're looking to do.
Well, look, I'll stick you in the defense attorney's chair here.
Oh my God. On this one,
you
know what, I can always do it though, Aaron.
Okay, so here's the thing. The cops roll up to the scene. The guy's there, he surrenders, I acted alone, okay? He admits he's done it. You know, they don't need to read him as Miranda right away because when there's an imminent sense of danger, it's one of those exceptions to the warrant requirement. And it's one that we don't hear about a lot. But they ask him a couple of questions just to see if everything's safe because they got these fake bombs laying in the snow. They got this car blowing up. They've got the defendant, you know, leaving a rifle on a neighbor's deck. You've got all of this stuff going on. Like they're trying to figure out, like, is this, you know, one person? Is it 5 people? Is it 10 people? Like, did, you know, hell open up and swallow this neighborhood? Okay, they're trying to figure this out. Well, the defendant incriminates himself right away. Okay, you know, he admits he's there. It's admissible. It's coming in. There's no reason to keep it out. I'm sure that the defense attorney probably tried. But where else has the defense got to go? If you're the defense attorney, where else do you go to try to defend this guy?
Oh, you absolutely. This is your best defense.
This is the last stopgap, and it's weak. I think this is weak. And, you know, people accuse me, oh, you're really friendly to defendants. Well, no, I'm not. I just recognize that the state has the burden of proof. I think the state is easily upholding its burden of proof in this case, beyond a reasonable doubt. Okay, look, you got a manifesto, you got the guy, you got the fake bombs, you got him in court, you're showing him off, you've got the guns, you've got all of this other evidence coming in. I don't see an issue yet. I think that there's something that the defense has a hook in with some allegation that there was not a proper mental evaluation done at some point. But again, it goes back to the point that you keyed in on, Misty. Just because the guy's off his rockers doesn't mean that he's not criminally liable.
Right. Criminal culpability, it doesn't just mean, okay, you're a little crazy. You can still know and understand that a crime.
What's the popular line that I hear people say? They say, well, this doesn't make any sense. Why is a defendant not guilty by reason of insanity? Well, if you're insane enough to commit a crime, shouldn't you be guilty? Well, oftentimes it's not a question of the guilt, it's a question of the punishment. Are you going to serve your time in a psychiatric institute, or are you going to serve it, a locked down psychiatric institute, or are you going to serve it in prison? Okay, so that's one threshold inquiry. But insanity in a psychiatric sense is not the same as insanity in a criminal sense. They're different meanings. This is not opening up the DSM and trying to figure out.
Not a medical diagnosis.
Yeah, this is not. This is a question as to whether or not somebody knew that their consequences were bad, basically.
Right.
And that's a pretty low threshold.
Definitely. So here, just to be defense attorney for 1 minute, and then we'll go back. I'll go back to being host and very objective. But here in Massachusetts, there is an interesting rule because the burden's on the prosecution to prove that the defendant had the capacity to commit the crime. This is a little different than other states like New York, where it's actually the defense burden to prove insanity. So it's a little bit more of a challenge for the prosecutor because you basically have to prove that they had the mental capacity, that they knew, not just knew, it's not just this institutional, I knew that I was committing a crime, it's understanding the criminality of the crime. Now, the facts of this case, not so good for a defense attorney. This is a tough uphill battle.
So the state's got the burden in Massachusetts. Okay, big deal in this case. I don't see a huge issue here.
But you got a better chance in Massachusetts than you have in other places because of that burden, because of where the burden lies. But
that's true. I will grant you that. That is correct, legally speaking. But in this case, the facts, to me, are so egregious, okay? As we know them today, I should say. Maybe something will happen and I'll change my mind. Maybe this so-called manifesto that's, close to 300 pages or something like that. Maybe the manifesto is going to have something in it that leads me to believe, did this guy think he was playing a video game or something?
Right. Well, that's one piece.
We don't know what's in it.
That could be the ramblings of someone who fits into the insanity defense. We don't know. We'll see medical experts, I'm sure, that are going to be.
That's been promised.
That has to. There's no other way to necessarily to prove to put forth that defense without having some experts on the stand.
From what I saw, the defense attorney who's leading the charge here, he's on the ball. He seems very, very sharp. I'm sure that this guy is getting competent representation to the best of that attorney's ability. But what's the old line? Cases are won and lost not so much on the attorney's ability, but on the facts, as they should be.
Right.
Okay. So I think that this attorney is doing what he can with what he's got, and he does not have a lot to work with.
No.
There's not a lot in his corner on this case. Again, as we know it today. But to the credit of the prosecutor and the local police officials, I will say this. They have kept a lot of the facts close to the chest here. They do not want to poison this jury. This is a small community. They did not, from what I can tell, go blab everything all over TV. You've got a lot of evidence that's becoming public for the first time in that procedure. Okay, in that proceeding that's going on in Massachusetts right now. So I give the local authorities a lot of credit for not going around and, leaking the manifesto. I haven't been able to find it online. I
was in a deep dive too, Aaron. I was really, really deep into the internet trying to find that thing, and I couldn't find it.
We can't find it. So they've got it. They're not leaking it. Good. It's going to come out for the first time in front of that jury. That jury is not walking into that courtroom with an idea of what's in it. They're going to see it with fresh eyes. It's the way it should be. Okay. We know that an incident happened. Everybody knew it. Okay. Some of the facts came out. The indictment obviously became public when the grand jury handed it up, okay. But a lot of the stuff here, the videos from the crime scene, I don't think have been made public. They're being played for the first time, and these were witnesses, neighbors, who pulled their phones out and said something bad's going on. We're hearing stuff. They go outside, they see a car in flames. They call 911. They start taping it. Then they hear the gunshots. Then they hear the victims scream. Okay, the videos come out in court. A lot of this stuff is coming out in court for the first time. So maybe it is that the defense has some hooks here that we just don't know about. But I think the prosecution's got a lot of stuff in its favor that also has not come out yet either.
Definitely. I agree with you. It's really great that the jury's not getting a tainted view of this case because a lot of the information's coming out.
I've been there and seen that before, and it casts doubt into the substance and quality of the verdict.
Definitely. But there are some facts that we do know and some issues that we know are going to be an issue because when you have a question of insanity, you're looking at that person's mental state at the time the crime was committed. So what do we know about the other two living victims? The ones that were injured that day. Are they able to testify? Do we anticipate their testimony? Because that would really speak to what happened to the extent that they remember at the time of the incident.
I believe they are planning to testify from what I have seen, but I don't have access to an electronic docket in this case. I haven't seen everything. My understanding is that, yes, they're going to be able to testify. I recall reading that analysis at some point. So that's going to be one of the highlights, or the climactic points, I should say, of the entire trial, is to sort of listen to that testimony, assuming that that's forthcoming.
Right.
The facts are just bizarre, and honestly, I don't know what to make of this. One thing that the defense attorney started in with yesterday, where he's trying to say that there might be like an autism or an Asperger's aspect to this, and it's just kind of like, huh? I mean, I cringed the way you guys did. Like,
because it's when
he starts bringing it up in the opening statement, and I'm like, that to me does not criminal insanity make.
No. Because again, as we spoke about, the difference is certainly you can be diagnosed with some sort of mental disorder, disease, defect, but that does not mean that you fall under the legal definition of insanity.
It is a question of whether this guy knows right from wrong, or should know right from wrong, okay? I thought that was just kind of a weird thing to inject into the opening statement. And, one of our guests who was on yesterday is like, seriously, this guy was in the Coast Guard. He went through some kind of vetting process.
Another problem for the defense, for sure.
And it's one of those weird things that I don't know if anybody's going to be able to argue that in trial, because we have no clue if the prosecution has been able to get his records. That is a convoluted process, and it's hard to jump through all those hoops. But just as a lay argument, this is, again, probably not one the jury will hear, but seriously, I mean, if this guy is as whacked out as the defense is, in essence, arguing, how the heck did he serve in the Coast Guard? Why was he stationed with the Coast Guard?
Right.
Don't they vet people out? If you're off your rockers, they don't want you in the military. They don't want you around weapons. They don't want you having your finger on the trigger. They want people who are going to effectively do the job of defending the country, but they want people who know when to exercise the power and when not to. That's kind of a core value of the military. You don't want crazy people with their hands on the buttons. So, I don't know. Part of me wonders, maybe the prosecution does have some records. Maybe the defense has some kind of records from when he was in the service. I don't know. I'm curious, though.
Yeah, I would think that if they were able to get the records, that would certainly be admissible, because you have to look back at the person's mental state, mental capacity, whether or not there were any issues that had been determined in the past. If the defense is going to make the argument that he snapped at some point, or that something changed, maybe based on his military experience, they're going to need those records to lay the foundation for that.
Yeah, I'm curious, because the old-fashioned rule, as you know, is that if somebody puts their mental state at issue, the other side, therefore, can get the records try to refute it. Okay, because that's just one of the old rules of evidence that we all know that we have to follow. Okay, that's just the way it is. So part of me wonders if that's going to bring some of these evaluations in, but I've heard rumblings that I have not been able to ferret out with my research, that when it comes to military records, there's kind of a wall there, and it's really, really, really hard to scale that wall and get into those records. So I don't know. I'm really curious, though. Maybe it'll come in, maybe it won't. If it doesn't, I'm still curious. Will I ever have my curiosity satisfied? I don't know, but I'm curious.
Yes. Well, we definitely have a lot more to talk about in this case, and I'm going to come back to you. But in the meantime, we're going to review some more testimony from the Eric Campbell case in accordance with what we're talking about. This is the psychiatrist that testified on Eric Campbell's behalf. She spoke about the situation that he experienced with his father and the trauma he experienced throughout his life, and testified on behalf of the defense. We can expect similar types of witnesses in the upcoming trial in the Loya case. So we're going to throw to that clip now.
One of the things that was remarkable was the documented experiences of traumatic life events that the psychologist conducting the evaluation identified at the time of her examination. The other thing was that Eric Campbell described himself as happy all the time and denied any feelings of sadness, which seems out of sync with all these traumatic instances, including his mother suffering the brain injury and being placed in a nursing home, and his father being incarcerated, which is suggestive of underreporting. It's also remarkable that she documented his tendency to use fantasy thought at a level that, so what she says here is he does tend to use fantasy to excess as a means of coping. This is known as a common defense mechanism among children who are experiencing trauma and violence in their lives. There's another finding here where he talks about, Eric reported that he sometimes has nightmares, and they're usually about someone wanting to kill children. Another thing that was remarkable was when asked to talk about his most, well, it says here, Eric is uncomfortable when it comes to openly discussing painful emotional issues. For example, when asked to describe his worst experience, he refused and stated he did not want to talk about that. Because of this discomfort, he may become socially constrained or even isolated. This finding is particularly important because of his age. It suggests that many of the everyday exchanges that contribute to development are either avoided or approached with excessive caution. So all of this is remarkable because this was at a very early age and long predated the incidents that lead to the current charges.
Now, you mentioned that there were some, in your mind at least, when you reviewed Nicholas Campbell's report, that there were some distinctions that you attributed to the difference in their ages. Can you tell us a little bit about that?
Yes, it's remarkable because Nicholas was 4 years older than Eric at the time that this report was conducted. There are several instances in which it appears as though Nicholas is actually trying to appear, again, better than he actually is. He's responding with sort of ideal responses. Again, similar to Eric, but in other areas apart from just feeling happy. He also was unable to. Well, when there's a test known as a sentence completion test, and in Nicholas's case, the psychologist noticed that he was very guarded. It says here, on a sentence completion task, he was also very guarded, but he completed the sentence, my nerves are running short. That's the completion of the sentence from Nicholas. The psychologist writes, of particular significance was his sentence, I can't ... feel anything. Again, these are symptoms that are indicative of stress that he's not reporting. I can't feel anything is specifically an indicator of numbing and avoidance symptoms in people who are experiencing trauma.
Now, Dr. Chaudhry, based on just that information, would you be able to diagnose a child or something like that with some sort of mental disorder, just based on that information?
No, not on that alone.
But would those be things that you would consider important in follow-up?
Absolutely.
Now, there's also Exhibit 50, which is the family evaluation, and were there things in that evaluation that were significant to you in your review of this case?
Yes, sir, there were. This was a family evaluation conducted of Edward Campbell, Nicholas Campbell, and Eric Campbell. Some of the remarkable things, first of all, was that the psychologists conducting the evaluations, sorry, not psychologists, mental health professionals who were conducting the evaluations actually administered rating scales similar to what we talked about earlier, to what I had administered to Eric. In those rating scales also there was sort of embedded questions that are designed to identify exaggeration or falsification of information. And it's notable that it says, Mr. Campbell received a clinically significant score on the defense responding subscale. Significant scores in this area suggest that the respondent may have answered in a socially acceptable manner. Therefore, all scores should be viewed with caution.
And when it says Mr. Campbell, who are they talking about?
They're talking about Mr. Edward Campbell.
Okay, the father.
The father, yes. So that's remarkable. The other thing that's remarkable is that in the section under summary and assessment, the report actually identifies areas of concern, child vulnerability, children exposed to violence, children's ages being 8 to 12, placing them at risk, caregiver capability, father engaging in violence with girlfriend, father has a history with APS and CPS, Animal Protective Services and Child Protective Services. Father has, there's a typographical error in the report, but the meaning is that father has not completed the grief process for loss of his wife. And father lacks family resources. Father admits caring for wife has impeded his ability to care for children.
So were these all things that you considered in assessing whether there was as corroborative evidence or corroborative information to the information?
I'm sorry, sir. Could you just repeat the question?
Well, in this particular case, Eric Campbell's father was also charged in this case. How did the fact that his father was involved impact your consideration of this case?
Yes, absolutely. Thank you for clarifying. At the time that these events were occurring, the events that were leading to these charges, I think this is very important to identify that not only is an individual who experiences, who suffers from PTSD, operating at a different mental level than a person who doesn't have PTSD, but in addition, that they're not just experiencing a stressful situation. Mr. Edward Campbell was actually experiencing a horrific situation. He was...
You mean Edward Campbell or Eric Campbell?
I'm sorry, Mr. Eric Campbell was observing this horrific act of violence, and the person who was perpetrating that horrific act of violence was the same person who had perpetrated recurring chronic acts of violence on Mr. Eric Campbell since he was a young child. Not only did that occur, but then also after the death of the victims, Mr. Edward Campbell, Eric's father, went on to tell him about how he had actually killed Eric's sister when she was an infant, and kept talking about how it's not usually this messy. And for Eric, this was a horrifying thing to add on to what he had already experienced. So a lifetime of being the victim of physical and emotional traumatic just abuse on a daily basis, of being beaten to the point where he was beaten into submission, and then witnessing this horrible act of violence committed by the father who had committed acts of violence to him, and then being told that his father had also killed his sibling, which he had never known before that. So yes, I think it's very significant that the perpetrator of this this act of violence, this horrific crime, was also a person that Eric had suffered from violence as a result of his actions.
Now, Dr. Chaudhry, do you have an opinion to a reasonable degree of medical certainty whether due to a mental condition or disorder, Mr. Campbell had the mental capacity to form specific intent to kill on the night of these events?
Yes, sir, I do.
And what is your opinion?
My opinion is that due to being incapacitated by his symptoms of post-traumatic stress disorder, as well as being incapacitated by the chronic effects of post-traumatic stress disorder, that when faced with the events of that night, he was unable to have the ability to exercise appropriate judgment or caution.
And do you have an opinion to a reasonable degree of medical certainty whether Mr. Campbell had the mental capacity to form specific intent to take property with the intent to permanently deprive the owners of its use?
Yes, sir.
And what is that opinion? Is it the same as?
Yes. My opinion is that he was unable to form a specific intent because of the way that his brain was functioning at the time of the events.
And do you have an opinion to a reasonable degree of medical certainty whether Mr. Campbell had the mental capacity to form specific intent to commit the felony of robbery with a dangerous weapon?
Yes, sir. My opinion is that he did not have the capacity to form specific intent.
And do you have an opinion to a reasonable degree of medical certainty whether Mr. Campbell had the mental capacity to form specific intent to kill the Faulkner's dogs?
It's my opinion that he did not have the capacity to form specific intent.
Now, I want to go back just briefly and talk to you about the symptoms of post-traumatic stress disorder. And you've named some of them in general. But I want you to talk to us a little bit about the symptoms as they relate to Mr. Eric Campbell, based on your review of this.
And on page 4 of your report, second paragraph, there are several recorded instances where the Texas Department of Family and Protective Services substantiated neglectful parenting by Ed Campbell. Do you see that sentence?
Yes.
And Eric was placed in foster care frequently. But that's not accurate.
Yes.
Is it accurate?
No.
But it's in your report that you based your opinion on.
Yes, this is a preliminary psychiatric report, and that there are that would be one of the inaccuracies in my report.
So have you done a final report?
My final report is being presented in this testimony.
Where is it?
As part of my presentation, as part of the conversation we're having.
So you haven't, the only written documentation that you have made of this report is what you are deeming the preliminary psychiatric evaluation that you presented with all of your opinions that you have stated here in this courtroom. Is that correct?
Yes, that's correct.
But this is not your report.
I would say that is my report, unless there's other additional information that emerges. That would be the report that I've submitted.
Well, all of this information you already had, isn't that correct?
Yes, that's correct.
So you had the Department of Social Services records before you testified in this courtroom today, didn't you?
Yes, that's correct.
And so you knew that him being the defendant being placed in foster care frequently was not correct. Isn't that true?
Yes, that's true.
But yet it's recorded as that in this report that was given to the state with your opinion in it.
That would be an error in my report.
And the same with the defendant not residing at the residence for the past 3 years. You knew that information before you testified today. Isn't that correct?
That's true.
And that also is an error in your report.
I would say neither of these is an attempt to mislead by omitting any information.
But it's what you based your opinion on.
What I would say is it's not merely the instance of his address or the frequency of him being held in foster care. I think what is relevant to my report and what really is the foundation of my report does not explain the address of Mr. Shane Worman's grandmother's home or how many times he was placed in foster care. The foundation of the report is based on a consistent pattern of isolation, of underreporting, of also his consistent reporting of the events that led to the present charges, the findings that not only I but also Dr. Fox had on his psychological evaluations that really identify that Eric Campbell, throughout the course of my assessment as well as Dr. Fox's, has not been trying to hide any information. So yes, there's an error in the frequency. Yes, there's an error in the address. Neither of those is indicative of any changes in my opinion on the mental state of Eric Campbell.
Well, you said that this was preliminary and that you were going to give some final report at some other time. Is that, or as you testify?
That's not uncommon to identify preliminary findings as well as final findings in testimony.
So you're going to prepare another report? Is that how that works?
There's no indicator that that needs to happen. We're here with the findings that I've already presented.
And in those findings, you just said, and you noted on page 9 of your report, under the history of the incident in question, you noted that it is also on the after history of incident in question, it's the first paragraph there, the last sentence. It's also notable that the account Eric gave me of this incident is very consistent with the police interview transcript. Is that what you stated here?
Yes.
And so would that be the police interview transcript that you reviewed of the defendant talking with Roger Baker on January the 1st of 2015 in West Virginia?
I don't remember the name of the officer.
Well, what police interview transcripts did you review?
I don't have them in front of me. I wouldn't be able to give you the names of the officers right off my memory.
On the front of your report, in the the second paragraph where you discuss what you examined, it says discovery files pertaining to this case. Does that include statements that the defendant gave to a law enforcement officer on January the 1st of 2015 while he was in West Virginia?
Yes, that's what I'm referring to.
And also a law enforcement interview that he gave to detectives Doug McPhee and Steve Hayes January the 2nd of 2015 while he was in West Virginia. Did you review that?
Yes, ma'am, I did.
And is it your opinion that the account that Eric gave you is very consistent with the police interview transcript?
I would say it's surprisingly consistent given the mental state and given the events that he had just gone through at the time that he gave those reports. And I think it's remarkable that even though several months have passed intervening, the reports, the basic account that he's provided has remained fairly consistent, not only with me but to other people that he reported.
Dr. Chaudhry, is it, so when did you interview Mr. Campbell?
The first time I interviewed him was in November of 2016.
Welcome back to the Law News Network, everybody. I'm Aaron Keller, and I have switched seats with Misty Marris. Just to confuse everyone, I'm hosting. She is still with us. She is the guest now. So that means I get to ask you the opposite questions that you asked me.
Rats, I really thought we were just playing musical chairs. You really tricked me.
No, that's not what we were doing. There's still chairs left, so we couldn't have done that. So we're just listening to testimony in the Eric Campbell trial, and we're hearing from Kathy Russin, our trial producer here, that the Campbell trial is not going to go to the penalty phase until perhaps the week of September 11th. That's the possible start date of the penalty phase. And again, as we've discussed many times here, when we're in a death penalty trial, the guilt phase is separate from the penalty phase. It's what's called a bifurcated trial, and that's because the U.S. Supreme Court says it has to be done that way. And that way, juries tend to not get as confused about exactly what they need to be deciding, when they need to be deciding it, and what facts need to be plugged into what laws to make sure that the sentence is legally correct. So that's going to be a couple of weeks away here. Yet another delay in this case that's been sort of on the back burner for about a month because a juror was in a car accident. Well, hopefully this straightens everything out and this case can get moving along. Bottom line is this testimony that we were just reviewing here is of a psychological expert who was really getting ripped on cross-examination about not having a final version of a report. She said, well, I'm just giving you my final analysis right now on the witness stand. I'm not producing a final report. Part of me wonders if there's just some evidence reason why they didn't do that, because if I'm remembering the rules of evidence correctly, Misty, and usually I carry them with me, but they're out of arm's length reach right now.
Should always
You're
have
shaking,
a pocket
you're
pack.
Shaking. I do. I do. It's just over there. One of the rules of evidence is that final reports can be looked at by the other side, but I don't believe preliminary reports can.
Yeah, final reports have to be exchanged. So sometimes when you do have an expert and you're getting expert input on a case, you are a little bit careful on from the attorney perspective about what actually goes into that final report. And sometimes you might have conversations with your expert, but it might not be memorialized into the actual final document that is obligated to be exchanged with the other
So
side.
this expert didn't even produce a final report, which just makes her look like she doesn't know what she's talking about. Interesting cross-examination tactic.
Right, and from a cross-examination perspective, when you do have an expert on the stand, that's your job. You have to take away the credibility of that expert. You use every piece of ammo that you have to say, look, this is just a hack put on by the other side to support their case. They didn't even make a report, blah, blah, blah. Whatever you can pull out, that's what you do on cross-examination. So not having that final report didn't give this expert a good shot.
I don't think that it helped at all. So one other question on the top of my mind as we listen to this is, in theory, it's a little bit of a preview towards what we're going to see in the death penalty phase, where we need to figure out what the punishment is for the first-degree murder conviction. And in this case, you're going to hear this kind of expert testimony about the defendant's psychological state, the relationship with his father, whether or not he had all sorts of mental health issues resulting from this abusive family situation that the defendant was in. So a little bit of a preview, I'm guessing.
Definitely. So in this case, in Eric Campbell, the expert that the defense was putting on was saying that because of the abusive past that Eric Campbell had at the hands of his father, because his father was so violent and intimidating and he was so scared of him, he suffered from post-traumatic stress disorder. And because he suffered from post-traumatic stress disorder, he could not formulate the intent to commit the crimes that he was charged with. Now, obviously, the jury didn't buy that at the end of the day. But from the perspective of what we're going to see in the next case that we're dealing with, the Adrian Loya trial, you're definitely going to be seeing some mental health experts on the stand there in a similar vein, except this time we're not talking about the inability to form intent to commit the crime. We're talking about not understanding the criminality of your conduct, a full-out insanity defense.
Yeah, let's make a list of all the ways that psychological expert testimony can make it into a trial. One is mitigation in a death penalty conviction, which is what we're expecting to come up in Campbell. One is exactly what we were just talking about, the earlier stages of Campbell, whether or not it's possible to form the criminal intent necessary to even get a conviction. And then the other way is to do what the defendant in Massachusetts is doing, and that is to claim mental disease or defect, which, I mean, kind of sort of gets into intent, but that's more about whether or not you even recognize what you're doing is wrong.
Right,
So
exactly.
it's sort of like three different standards, but it all results in similar evidence being presented to a jury.
It's the same idea, exactly. So in Campbell, that was actually, it was an interesting technique by the defense, because what they were trying to show was that that Campbell was basically coerced into this by his father, that because he suffered from PTSD, yes, he did, he went through the motions, yes, he knew it was wrong. It's not that he didn't understand that his conduct was wrong, it's that he could not formulate the intent based on the PTSD to actually commit these crimes because he was at the hands of his abusive father. So that's a different way of using expert testimony. In Loya, we're going to see a different spin. This is going to be, this person suffers from a mental disease or defect that they cannot understand the criminality of their conduct. And it's an affirmative defense. That means this person is going to be found not guilty by reason of insanity and possibly serve time in a mental institution as opposed to in a prison.
Well, that's if the jury so decides.
If the jury so decides,
the
you're right.
jury
I
could turn
jumped the
around and
gun,
just
which
say-
is bad as the defense attorney on.
Yeah,
but
the jury could just turn around and say, hey, look, you knew what you were doing. You wrote this manifesto. You traveled all the way up to New England from Virginia, and, you had this plan that allegedly you hatched because you claim to have been sexually assaulted by this woman when you were in the service with her in Alaska. This is something that was years in the making, according to the defendant's own words.
Right.
That doesn't sound like not understanding the consequences of your actions.
You're right, because that's the key. It's, do you know and understand your actions? Do you understand your criminal conduct? And in a case like this, where in the defendant's own words, he says, well, I was abused, and that's what led to this. Well, retribution is not a lack of understanding of criminal conduct. You're talking about revenge, essentially. That's a different, that's not going to absolve you of criminal liability.
Yeah, so let's just, for sake of discussing what this actually means legally, let's talk about conduct that would result in a textbook definition in not guilty by reason of insanity. What would that defendant look like? Textbook example.
We've seen a couple of these cases, actually. What happens is the person very often after the fact maybe doesn't run from the police, truly doesn't understand. There was a case in the South where the person who committed a murder actually walked outside with the body of his victim. And in a case like that, that is someone who doesn't understand that his conduct was criminal. Somebody who pops up and is like, wait, what happened? I don't remember anything. Something like that could actually fall into that definition. Anytime there's evidence that you understand what you're doing, that you plan or prepare for a crime, that during the commission of the crime you have plans in place. For instance, in this particular case, you have music that's coordinated with your crime. You're wearing a GoPro to capture the crime. You're going to be in trouble from an insanity perspective. Also, your actions directly after the crime. Did you do something did you run from the police? That undercuts an insanity defense significantly.
Exactly. I mean, this is a different bar than what would be required to get a diagnosis in the Diagnostic and Statistics Manual, that a psychiatrist would use. So we appreciate you pointing out the difference, because it's critical to understand the difference between criminal insanity and psychological insanity.
Right.
Not the same thing.
And you said something that's often brought up. That's, hey, isn't every person that commits a murder a little crazy? But that doesn't alleviate criminal culpability. Mm-hmm. And that's exactly the point here. You really have to be detached from reality. That's why insanity defenses are tough, because you have to show that you truly do not understand or comprehend what you did was wrong. Very often that evidence comes from your reaction after the fact. If you run, you have a really difficult time proving an insanity defense.
Exactly. We're going to dip back into the testimony in the Eric Campbell trial. I know we were switching gears pretty quickly on everybody there, but we want to go and listen to some of the remaining testimony of the psychological expert who we were sharing with you just a few minutes ago. And that's where we'll go next. So we'll be back in a couple of minutes.
Now, I want to go to the transcript of give you what's been marked as Exhibit 4, Exhibit 13. If you'll take that.
Okay, thank you.
Now, on the defendant's Exhibit 13, the transcript on page 2,
Yes,
the fifth from the bottom,
yes,
does it say he just came on the trip because he saw his dad emotionally distraught?
yes, that's what it says.
During these discussions with Detectives Hayes and Misty, does Mr. Campbell, based on your memory, talk about his drug problems in the past?
Yes, sir.
Does he talk about, on page 20 at the bottom, the last Ed Campbell statement, at the second to last sentence, then when she started carrying the phone around again in her hand, I started going through her shit, I wrote through this officer protective program. Based on your experience, is people who are trying to control others, is use taking their phones or monitoring their phones one of the tactics they use?
Yes, sir. That's one of the tactics of spousal emotional abuse, controlling tactics.
And does he talk on the other phone? So I took both of her phones from her?
Yes, sir. In fact, one of the things that I would say is remarkable is that not only was he getting sort of breaking into her phones, but he was aggregating her phone use records and.
Now, begin on page 31, at the top under Ed Campbell.
Yes, sir.
And does it talk about, he says, I wasn't going to let him get arrested.
Yes, sir.
And he says that boy didn't have anything to do with North Carolina bullshit.
Yes, sir.
Now, and does it say in the next time it says Ed Campbell, he has some suspicion of things, but I'm an authoritative dad, as you might expect. He's not going to question me. He's trying to get me to go back to Texas. I knew he figured he's a smart boy. He figured that car was stolen. He's not stupid. He never questioned me. That's disrespectful. Now, would that be consistent with your, at least, your understanding of the pattern of Edward Campbell's relationship with other people, and especially Eric Campbell?
Yes, sir. In fact, what Eric Campbell shared with me was that when he asked Ed Campbell why he was changing the license plates, Eric was looked at his dad, and his dad actually held a screwdriver up to his head and growled at him and threatened him. And Eric shared with me that he was terrified because his father had injured him with a screwdriver before. And so he stopped questioning his father.
Now, on page 37,
Yes, sir.
does the third line down,
Yes.
there's been a lot of, you've been cross-examined a great deal about whether Mr. Edward Campbell was physically and emotionally abusive toward his children and family. Does this say, yes, I bruised my children, punishing them? I have. The older ones, too, I bruised them. Now, would that lead you to believe he's bruised the younger ones?
Yes, sir.
Like it said of siblings?
Yes, sir.
They know I'll wig out on them if they're disrespectful. Is that what he said?
Yes, sir.
What he appears to have said? Would that be consistent with the history that you gathered from the collateral sources as well as Mr. Eric Campbell?
Yes, that he had a very volatile temper, and that he would unpredictably become very violent to family members.
And then on page 38, down 1, 2, 3, 4, 5, from the bottom, it says Ed Campbell. My wife would say every little bruise I put on all the kids, she'd take a picture of it, and I found. Wow, why are you collecting this information?
Yes, sir.
And then he says in the next line, I'm not a child abuser.
Yes, sir.
Now, at the very last line, I don't have to spank my kids because they know I'll rip them a new asshole and it works. It really does. When I do spank them, I beat the shit out of them.
Yes, sir.
It sounds bad, but yeah, I put grab marks on them. Was there a grab mark noted in the medical report from Eric Campbell, who was 8 years old, that the prosecutor questioned you about?
Yes, sir.
And they never backtalked. Did he talk in here about, on the next page, page 39, at the very, on the first paragraph,
Yes, sir.
one time one of my nephews, he wasn't going to do dishes. He was 16 and didn't want to do dishes when it was his turn to do dishes.
Yes.
And then in the next line he said, no, I'm not doing the dishes. I said, what? And I said, I'm not going to do all
turned him upside down and I did dishes with his head. Is that what he said?
Yes, sir, that's what he said.
And he still hits you to this day. Is the next one.
Yes, sir.
Now, on page 40, on the next page, does he talk about his the way he treats other people's children at the top?
Yes, sir, I believe he's referring to the pastor's child.
And now, one of the issues, there's been
More testimony from the Eric Campbell trial. Again, that trial will move into a penalty phase to determine whether or not the defendant should be sent to death row or should receive some other punishment. We're expecting the penalty phase to pick up in a couple of weeks. In that particular clip, we're hearing a lot of pieces of the puzzle getting put together, and there are just so many pieces. It's hard to figure out just how abusive this family situation was. We've got this discussion about the father holding a screwdriver up to the son's head and growling at him. We're hearing evidence of grab marks that would indicate some kind of abuse as early as the defendant being 8 years old. Talking about the ways that the father was trying to go about committing all these criminal acts. So again, Misty, we're back getting a preview perhaps of from the first part of the trial into what we expect in the mitigation trial. Okay, the jury convicted him, bottom line. They think that he did play way too much of a role in this crime spree. He was not just, some innocent son dragged along who, begged to get out but didn't have an opportunity to get out. They found that he had an opportunity to get out, as I understand it. So how does this come in from a mitigation standpoint?
Well, we brought up another point earlier that I think plays into this whole thing, and that's the fact that the trial is bifurcated, and that's for this very purpose when you're talking about the penalty phase, when you're facing a capital murder charge, the death penalty. Very important that both of those come in at different times in order to ensure that the law is being applied appropriately, because just because you're convicted of first-degree murder, just because you're convicted of a crime with intent, doesn't mean you're facing the maximum penalty under the law.
Did this conviction surprise you in any way?
Not at all. I was watching this trial gavel to gavel, just like you were. I was not surprised that Eric Campbell was convicted. I thought his defense was the best the defense attorney could put on, but there was too much evidence pointing to the fact that there was an accomplice situation here. So even if Eric Campbell did not want to participate in a burglary, even if Eric Campbell didn't want to participate in the killing of these two people, didn't go in with the intent of killing these people, it doesn't really matter because he did participate. And to say that it's only because he was afraid of his father when there were ample opportunities to get out and retreat, I'm not surprised that this resulted in a conviction.
Yeah, I agree with the analysis. I'm surprised that the jury went for the top charge, though, because I will agree that the evidence tends to point that the father was really the guy steering the ship. Okay, that doesn't necessarily mean the son should be off the hook, but I'm surprised that they went for that top charge.
See, I think,
but is that felony murder rule coming in?
Yeah, felony murder. If you go in and you commit a violent felony, and those felonies are enumerated in the statute, and one of them is burglary. If you go in to commit a burglary, a robbery, a violent crime, and somebody dies in the commission of that crime, that's felony murder. It doesn't matter if you didn't want that person to die, if you had no intent to commit the murder. Maybe the dad did, but just because the son, Eric Campbell, was involved in that underlying crime, he's guilty of the murder. That's just the basic rule. And not to mention, the prosecution did put on some evidence that would tend to show his participation in some of that. For instance, there was a lot of evidence about the brutality of the beatings against the Faulkners. A lot of evidence that would indicate that one person wasn't committing all of the violent acts. And also, I think from a jury perspective, and I thought this too, the dad's not there. He's obviously a bad guy. He committed suicide. He left the bag in Eric's hands. He's the only one who's going to be liable for this crime. But Eric Campbell's account of the facts is the only account of the facts.
Yeah, I agree with your analysis 100% here. So we are in agreement. We'll continue listening to some of the testimony from the doctor who's on the stand giving a psychological view into the defendant's life. Again, this was from the first phase of the trial. The second phase is coming up probably in about a week and a half.
About the use of cell phones around Mr. Edward Campbell.
Yes, sir.
On page 48, 6 lines from the top where it says Ed Campbell. You can come to my home, take your battery out of your cell phone if you have one. Would say that.
Yes, sir, that's right.
Was that something that Mr. Campbell, Eric Campbell, told you that he left his cell phone at home and the reason why?
Yes.
Did he say it was at his father's?
Yes. Yes, sir, he did.
You know, page 106 at the bottom, did he talk about, I'll give you a hand, I taught my son terribly with my kids.
I'm sorry, sir, what page is that?
106 at the very bottom.
Yes. I've taught my son parables with a belt, with my fist. I've taught him a lot of different ways. Now, I've never really punched him, but I punched my older son a couple of times.
And does he say he never punched me back, though?
That's right, he never punched me back, though.
Now, the prosecutor asked you a lot of questions about collateral information, Dr. Salisbury. Was the basis of the post-traumatic stress disorder the history of the child abuse and the chaotic, the pattern of chaos in the home?
Yes, sir, that was the basis.
And was that the basis for you as well as the doctors at the prison?
Yes, sir, that's correct.
And would it appear that Mr. Campbell in those transcripts was confirming a lot of the stuff that you had learned through the CTS reports, Child Protective Service, as well as from Mr. Eric Campbell?
Yes, sir. It's actually quite remarkable that Mr. Ed Campbell was boasting about hitting children. He was actually boasting about how badly he had beaten, I think, the pastor's son, and threw him in the pond and chased him down and slapped him so hard you could see hand marks on his legs. So it's quite remarkable that not only is he reporting that he did it, but he seems to be quite proud of that.
And now I know that he talked a little bit about the things that happened at the home, but did those things appear to be consistent with the things that Eric Campbell told you about his, at least his role in it? Maybe not the details, but his role in the father's death.
Yes, sir.
I think that's those questions.
Dr. Shaw, are you referring to, I believe it's Defense Exhibit 4, the interview of Mr. Campbell
Yes, ma'am.
On page 18 and 19, and again, you say that you reviewed these as part of your collateral information before you completed your report.
Yes.
Is that correct?
Yes. But not before I interviewed Eric.
Before you interviewed Eric,
No, I said, but not before I interviewed Eric.
but before you completed your report.
Yes, ma'am.
And on page 18, it says Campbell says, and I think you know there's proof for that too. I know there is cause, there ain't any fingerprints or anything that had to do with those deaths. Those people I killed. Did you see that?
Yes, ma'am.
And on the next page, page 19,
Yes.
6 down, Campbell, when he jumped in that fucking truck, I even put the blue buckets in the, no, he moved the blue buckets, his fingerprints might be on the blue buckets on the outside of the, but that's about it. And, do you see that?
Yes, ma'am.
And Deed says, yeah, right. Campbell says, but there's nothing. I'm sorry, he says, right, yeah. And Campbell says, but there's nothing on the, and he says, Deed says, well, now, he told me he helped load the bodies. I mean, just so you know, I don't want you to jam yourself up here either. And Campbell says, thank you, I appreciate you. And Deed says, he's like, I say he's been cooperative, so, you just got to try to. And Campbell says, I appreciate you, sir, thank you very much. You see that?
Yes, ma'am.
And Deed says, try to make sure you don't. And Campbell says, I understand. And Deed says, don't jam yourself up. You see that?
Yes, ma'am.
And at the end of that page, Pendleton said, is the only thing that can help you to help Eric, because I think we know what Eric's done based on what he's told us his truthfulness. And then later on the next page, Pendleton says, and if you try and manipulate what happened, even though you're taking responsibility for it. Do you see that?
Yes, ma'am.
And then the next thing that Mr. Pendleton says, or I'm sorry, Captain Pendleton says, is when you try and manipulate the facts of what's known and what's not known. And Campbell says, I understand what you're saying. And then Captain Pendleton says, trying to make Eric, to help Eric make it look worse, that could ultimately make Eric look worse.
Yes, ma'am.
Campbell says, I understand what you say. I agree with you. Do you see that?
Yes, ma'am.
And on the next page, on page 21, Mr. Campbell says, I agree this. You just said everything I needed to hear when you told me that he helped load the bodies. You see that? 1, 2, 3, 4, 5, 6 line from the top, page 21.
Oh, I'm sorry. I'm looking at the wrong page. 1, 2, 3, 4, 6. Yes, ma'am.
And later down that page, 7 from the top, Mr. Campbell said, what else did Eric say he did? And Deed says, I can't go into a hole. And Mr. Campbell says, I understand. Do you see that?
Yes, ma'am.
And on page 22, Mr. Campbell says, thank you for saying the one. You see that?
Yes.
And then Mr. D says, I just don't want you to, and Campbell said, jam myself up. I heard you. Do you see that?
Yes.
And on page 59 of this, I believe Mr. Tyndall asked you about this, that Mr. Campbell, forward from the bottom of that, says, yes, sir, recommendations on how I can manipulate one of them to get an attorney for my son. You see that?
Yes.
second from the bottom, when Mr. D says, you got to keep in mind, is Eric, Eric is an adult. He can make whatever kind of decisions. And Mr. Campbell says, exactly, yeah. And on the next page, Mr. D says, you know what I'm saying. And Campbell says, he already has. And then Deed says, he has. He's made decisions, adult decisions already. And Campbell says, yes, sir. And Mr. Campbell says, but if you can manipulate the DA or not manipulate, influence the DA so I can see my son, that would be appreciated. Do you see that?
Yes, ma'am.
In fact, he was pretty interested several times about when he could talk to Eric, wasn't he?
It appears so, yes.
You didn't write anything in your report about Ed Campbell's statements to law enforcement.
No, I didn't.
You didn't write anywhere in your notes about Edward Campbell's statements to law enforcement, did you?
Ma'am, I covered that material on the front page of my report where I reviewed the discovery files, and this was included in the discovery files. I didn't refer to it specifically.
You never refer to it specifically.
That's correct.
And you refer to other collateral sources specifically in your report. Isn't that correct?
Yes, that's correct.
Your Honor, I don't have anything further. I renew my objection.
More testimony from the forensic psychiatrist in the Eric Campbell case out of North Carolina. One thing that sticks out there is this description in these reports that the father of the defendant, who was the co-conspirator in this crime spree, which ended in the murders, the father liked or bragged about abusing kids. So, Misty, what does that tell us about this family dynamic that we already know is messed up?
Yeah, that's a really compelling fact. You're talking about somebody who is bragging about abusing his children, which will lead you to believe that that abuse was real, that abuse sticks with that person, that they're growing up in this environment where maybe they don't totally know right from wrong because of the being at the hands of this person. So it certainly speaks to the fact that this was not a pleasant childhood for Eric Campbell, that this was a very abusive man and that a criminal.
So again, we're back to that old dichotomy: good evidence for mitigation, but not necessarily good evidence at the stage of the trial in which it was at least presented the first time. Not great evidence to indicate that he's not guilty.
Right.
Okay,
that's
but
the
good
difference.
mitigation evidence.
Great mitigation evidence, not so great to say that just because somebody grew up in an abusive home, it negates their culpability for committing a crime. Certainly very different with respect to the mitigation aspect of the case.
Woe is me versus I can't tell the difference between right and wrong.
Yeah, absolutely. Completely different uses of maybe the same or similar testimony. One of the reasons why bifurcated trials, especially in capital punishment cases, are really important.
Exactly. Well, I know you need to hit the road. You have stuck around way longer than usual